Did you know that millions of people living in the United States could be at risk of displacement after a major immigration bill quietly passed through Congress? This isn't a future proposal or political debate. It's real, it's finalized, and parts of it begin taking effect in 2026. While headlines focus on border security and enforcement, the real impact may hit workers, families, visa holders, and long-term residents who never expected to be affected. These new laws are complex, poorly explained, and already being misunderstood. In this video, we'll break down what Congress actually passed, who could be forced to leave, why these changes matter right now, and what steps may still be available. Staying uninformed could cost you everything. What Congress passed is being described publicly as a necessary update to modernize the immigration system, but the reality unfolding behind the scenes is far more disruptive. This is not a single law aimed at one group or one issue. It is a layered package of enforcement expansions, eligibility restrictions, funding reallocations, and procedural changes that together reshape how immigration status is evaluated, renewed, and enforced inside the United States. The reason so many people are unsettled is not because they suddenly broke the law, but because the law moved underneath them. At the center of this shift is the way enforcement priorities are being redefined. For years, immigration policy relied heavily on discretion, backlogs, and uneven enforcement. That created a false sense of stability for millions of people who lived, worked, and raised families in the U.S. while navigating temporary or conditional status. The 2026 law changes that equation. Enforcement is no longer reactive or selective in the same way. It is systematic. Automated checks, cross-agency data sharing, and stricter timelines mean that falling out of compliance, even briefly, can now trigger consequences that escalate quickly. One of the most affected groups will be individuals living in the U.S. on temporary visas tied to employment. These include workers in technology, healthcare, construction, agriculture, and service industries. Under the new law, employer compliance requirements are expanding while grace periods for workers are shrinking. If a company loses eligibility to sponsor, fails an audit, or restructures its workforce, employees can lose status almost immediately. Previously, workers often had months to find alternative sponsorship. Under the 2026 framework, that window may be reduced to weeks, or eliminated entirely in some categories. For families dependent on a single sponsored worker, this turns a routine job disruption into a potential forced departure. Students are facing a similar tightening. International education has long been treated as a pathway into the U.S. economy, but the new law reframes student visas as strictly temporary with limited tolerance for deviation. Course load requirements, reporting rules, and post-graduation work authorizations are all being enforced more aggressively. A delayed internship, a mismatched employer filing, or a late status update can now invalidate legal stay. For students who expected time to adjust after graduation, the message is clear. There is far less room for error and far less sympathy when mistakes occur. Another group quietly placed at risk consists of people living in the U.S. under humanitarian or discretionary protections. Temporary protected statuses, parole programs, and deferred action categories are being narrowed and subjected to stricter renewal standards. Many of these programs were created in response to crises and were repeatedly extended, leading families to believe their status would continue. The new law reverses that pattern. Protections are now being sunsetted rather than renewed by default, and eligibility reviews are becoming more restrictive. When these protections expire, individuals are often left without any viable pathway to remain, regardless of how long they have lived in the country. Mixed-status families are among those facing the most painful consequences. In households where one member is a citizen or permanent resident and another relies on a temporary or pending status, the new law increases the likelihood of separation. Processing delays, higher evidentiary burdens, and stricter interview standards mean applications may not be resolved before current status expires. When that happens, individuals may be required to leave the U.S. while waiting for a decision. The law does not account for the human cost of this separation. It treats each case as an administrative matter, even when families are torn apart. People with old or minor immigration violations are also being pulled back into focus. Under the new framework, historical records are playing a larger role in present-day decisions. Overstays, unauthorized work, or technical entry violations that were once overlooked or forgiven can now result in denials or enforcement actions. What is especially destabilizing is that many people believe these issues were resolved years ago. Now, during renewals or status reviews, they are resurfacing, often without clear guidance on how to address them under the updated rules. The role of federal agencies is central to how this law will be felt on the ground. United States Congress may have passed the bill, but enforcement falls to agencies like Department of Homeland Security, U.S. Citizenship and Immigration Services, and Immigration and Customs Enforcement. These agencies are now operating with expanded authority, increased funding, and clearer mandates to act quickly when status issues arise. What once took months of correspondence can now escalate into removal proceedings in a fraction of the time. Renewals, which many people treated as routine paperwork, are becoming a critical point of risk. Each renewal is now effectively a reassessment. Income thresholds, employer compliance, residence history, and even travel patterns are being reviewed against updated criteria. Someone who qualified 5 years ago may no longer qualify today, not because their situation worsened, but because the standards changed. This is especially dangerous for people who travel abroad and attempt to re-enter, as re-entry decisions are increasingly final and difficult to appeal. Economic factors also intersect with the new law in ways that could displace large numbers of people. Several visa categories are tied to wage levels, labor shortages, or employer size. As these thresholds rise, some employers will no longer be able to sponsor workers. Small businesses and nonprofits are particularly vulnerable. When sponsorship ends, workers are often given extremely limited time to secure alternatives. For many, that is not realistic, especially in competitive or highly regulated fields. Undocumented individuals are not explicitly the focus of every provision, but the environment they face is becoming more restrictive. Data integration across agencies is expanding, making it easier to identify individuals without status through employment records, housing data, and state-level systems. While mass removals are not announced publicly, the increased likelihood of detection creates constant instability. Everyday interactions with institutions now carry greater risk than before. What makes this situation more alarming is how quietly it is unfolding. The law is complex, and its most impactful provisions are buried in regulatory language rather than public announcements. Many people will not realize they are affected until they receive a notice, denial, or enforcement action. By then, options are limited. Legal remedies are narrower, timelines are shorter, and the emotional toll is immense. The broader consequences extend far beyond individual cases. Entire communities depend on immigrant labor, cultural contribution, and economic participation. When people are forced to leave suddenly, businesses lose experienced workers, schools lose students, and families lose stability. Yet these downstream effects receive little attention in official explanations of the law. The focus remains on compliance and control, not continuity or integration. As 2026 approaches, the most dangerous assumption anyone can make is that nothing will change for them personally. This law is not about dramatic raids or headline-grabbing deportations. It is about attrition. It is about tightening the system until people fall out of it, one category at a time. Those who understand this early may still have options. Those who wait may find that the decision has already been made for them. What we are witnessing is not just a policy update, but a fundamental shift in how immigration stability is defined. Legal presence is becoming more conditional, more fragile, and more dependent on constant compliance with moving standards. For millions of people, the question is no longer whether they belong in the United States, but whether the system will allow them to stay.